Derek Chauvin is back in the news because he is getting scheduled for sentencing, and Judge Cahill just today issued a new order that is saying that some of the aggravating factors that they were fighting over are going to, in fact, apply to Derek Chauvin, which means that the potential sentence that he faces is aggravated. It means it gets worse. And so we want to break down what is going on here. To start, we're going to get some background information coming over from CBS Local, the Minnesota affiliate. You may remember, we spent a lot of time on this channel talking a lot about Derek Chauvin. We covered the entire trial. And the trial's, it's done. It's over, right? Derek Chauvin has been convicted. He's got 3 convictions, all 3 charges. But he hasn't been sentenced yet, and that is something that is up to the judge to decide how much time a person gets. So, when you're doing a trial in front of a jury, all the jury is doing is helping us decide what the facts are, whether or not somebody did something, and then the judge gets to decide what the penalty is. So we're sort of done with the fact-finding phase of this case. Now we're moving into the sentencing phase, which is a whole different can of worms. I mean, there's a lot going on here. And I want to show you a little bit about how this works, but let's start by getting some background information over from CBS Local. This article says that Derek Chauvin's conviction, a judge says that the prosecutors proved multiple aggravated sentencing factors, including cruelty. Judge Peter Cahill said that they did so beyond a reasonable doubt. They proved some aggravating factors, including the cruelty. Minneapolis police officer Chauvin was convicted. He's set to be sentenced on June 25th. It was originally scheduled for June 16th, but then it was pushed back. According to Cahill, the judge that we spent a lot of time watching, prosecutors have proven beyond a reasonable doubt that Chauvin abused a position of authority, right? He was a police officer. He treated Floyd with particular cruelty, and children were present during the commission of the offense. And so all of these things are going to be aggravating factors. They're also saying that he committed the crime as part of a group. They say here it was particularly cruel to kill George Floyd slowly by preventing his ability to breathe when Mr. Floyd already made clear he was having trouble breathing. The motion said on the cruelty factor. And so the way that this works is, let me give you the high-level overview on some of this stuff. So when you are talking about sentencing, I want to show you a chart here in a second, but before we get there, let me give you the high-level stuff. So let's say, for example, you're charged with a Class 4 felony. So in Arizona, we have 6 different scales, or 6 different numbers of felonies. Class 1 all the way down to Class 6. Class 1 is going to be the most serious for a crime like murder. Class 2 is sort of less severe crimes like rape, sexual assault, those types of things. Then we work our way down. So let's say that you're Derek Chauvin and you're charged with a Class 2 or whatever the equivalent is here of whatever he was charged with in Minnesota. We have different criminal law statutes, so it's different. But let's say he was charged with a Class 2 felony for unintentional manslaughter or murder, which he was convicted of there. Well, what we would do in Arizona is we would look at what are called sentencing charts. And so we would literally open up a sentencing packet that has all of these different spreadsheets in it. And you would just look on the chart and you would say, okay, Class 2 felony. You go down the column, Class 2, you go over, and you've got these different categories of offenses. You've got Category 1, 2, and 3, and so on. And this is kind of the same structure, the kind of the same scheme that you'll see in many other states throughout the country. You're basically looking at charts. And so when you are navigating down and you're sort of going down the column and then scrolling over on the chart, you're going to see what's called a presumptive term. And this is where people were sort of kicking around the idea for Derek Chauvin, 10 to 12 years, 12 to 15 years, because they're looking at the charts. They're looking at the scale and they can say, all right, well, based on the factors that we have identified thus far, he falls in this box. Now, what is happening now is the government is saying, well, that box is not appropriate. That's just the presumption. That's where we all start. We know it's a Class 2. We know he doesn't have any prior felony convictions. We know, all the facts and the pertinent details of the case. And so when we go through our spreadsheets and find where to put that pin in the chart, we're looking at the presumption. Everybody starts right there based on the factors. But the government came in and said, yeah, but that's not enough. There are a lot more important things that happen here that are called aggravating factors, right? He was cruel to him. He did this in front of children. There were other people. He did this as part of a group, right? So it was more heinous because it was sort of a gang activity. Well, all of those things are aggravating factors. And so it's going to take it out of that box that is the presumption right there in the middle, and it's going to move it towards a higher, more severe sentence. That's the government's job. They're ramming it that way to make it more severe. It's cruel, children are around, did it as part of a group. Okay, got that. The defense now, they're arguing the other direction. So they're going to come back with a bunch of the judge didn't buy any of it, mitigation that sort of goes the other direction. Well, he's never been convicted of anything. Well, he's a family man. Well, he, was relying on training. He had a long history serving his community as a police officer, blah, 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 blah. Then what the judge does is weighs both factors. The government submitted all these aggravating factors. The defense submitted all these mitigating factors, and the judge needs to split it and sort of decide, well, this is what applies. And Judge Cahill did and found that all of those aggravating factors, or a lot of them, applied. He said it was particularly cruel to kill Mr. Floyd when he was already having trouble breathing. He also says the victim, being particularly vulnerable, was not proven beyond a reasonable doubt. So 4 out of the 5 aggravating factors brought before the judge were found to be proven. It means the judge could go with a longer sentence for Chauvin than the sentencing guidelines would indicate, which would be a minimum of 12 and a half years. In early May, defense attorney Eric Nelson filed a motion for a new trial, stating that the court violated Chauvin's constitutional rights for several reasons, including not allowing the trial to move outside of Hennepin County and not sequestering the jury the entirety of the case. He also says the jury committed misconduct and wants a hearing to throw out the verdict. So you can see over here from a couple people over on Twitter said, breaking court finds multiple aggravated sentencing factors in the Derek Chauvin case. He abused a position of authority, number 1, treated George Floyd with cruelty, number 2, children were present, number 3, committed the crime with a group with the participation of at least 3 other people, which is number 4, which were the other officers, right? And he says, bottom line, finding 4 of the 5 aggravating factors mean the judge can sentence him to more than the guideline of 12 and a half years. So you can see that this stuff it can sort of start compounding quickly. I want to see if I can pull up a link here for you that shows you what the sentencing guidelines actually look like, because it is a big, big document. So this is over from the Minneapolis criminal statutes. I didn't pull this up before I started recording. My apologies. But let's take a quick look at this. So the Minnesota sentencing guidelines, along with commentary, and this is a big document. Look, 147 pages. So I just wanted to scroll through this and show you kind of what they're all taking a look at. Sentencing guidelines, commission. We have determining presumptive sentences. So they're looking at things like the offense severity, the criminal history, the presumptive sentence. Where do you all start, right? Where does everybody start? You start at the presumptive, and you can just see we're going to work our way down. Let's see if we can find any charts maybe that will give us some guidance or give us some here we go, severity level of a conviction offense. So you see here, Minnesota statute requires the guideline provide for a range of sentences that are presumptive. The minimum sentence can't be less. The maximum sentence can't be more. Okay, so you just see how this works. It's complicated stuff. So you can spend a lot of time sort of kicking these rules around. So the prosecution can come in and say, well, we think that the criminal history score is higher or lower, and then they can just, bounce around these charts. This is literally what we're talking about. They just go down these charts. This is even more complicated and convoluted than Arizona's. We have a lot of this, but we sort of have it organized, I think, in a better way personally. But maybe I'm not familiar with this document. But you can see, right, 147 pages for sort of navigating these sentencing rules, sentencing worksheet, sentencing guidelines. A lot. There's a lot going on there. So the judge ultimately came out, went through everything, and said, here's what we find. This is our verdict and findings of fact regarding the aggravated sentencing factors. And this, again, we know this court very well. We've spent a lot of time here. Says that the court, acting as the trier of fact with regard to sentencing facts, finds the following facts support an aggravated durational departure. They have been proven beyond a reasonable doubt. So, of course, as we know, May 25th, he was employed as a police officer in full uniform, and he used a restraint that the jury determined ultimately caused Floyd's death. So you may disagree with this, but the jury says this happened. Right? And the judge has to go on that basis. The judge can't sort of take what the jury listened to and throw that out. They could, theoretically, but they didn't in this case. So they're going to be leaning on the jury verdict. And the jury said that Derek Chauvin killed George Floyd. So on that basis, the judge has to then apply additional facts to that fact, to that finding. As a police officer, the defendant, Derek Chauvin, had a position of trust and authority with the community. The trust placed in the defendant included trust that anyone arrested would be treated with respect and only with reasonable force. Defendant abused his position of authority by using force that the jury has determined in returning its verdicts exceeded the authority granted by the peace officers. So the judge is really connecting this back to the jury verdict. Specifically, the defendant with two other officers held Floyd in a handcuffed position with the knee on the neck, prolonged period of time, 6.5 minutes, informed the restraint. Not only was a danger to asphyxia theoretical, it was communicated to the defendant because George Floyd, because it was actually occurring. Basically, George Floyd was complaining that he couldn't breathe, and we know that Derek Chauvin heard that. When it became clear, even to bystanders, that he was in medical distress, was no longer responsive, and had ceased breathing, defendant further abused his position of trust and authority by not rendering aid, by declining 2 suggestions from one of his fellow officers to place Floyd on his side, and by preventing bystanders, including an off-duty Minneapolis firefighter, from assisting. I'm not so sure that I agree with that particular point there. Yes, what Chauvin did, of course, was not humanitarian, right? He could have handled the situation much differently, but I don't know that the fact that you have an officer not allowing Genevieve Hansen, the firefighter, to come in and perform resuscitation or provide medical services, that does not seem inappropriate to me, right? He didn't know who she was. She wasn't in uniform. She wasn't part of the official response in any way, shape, or form that I recall. So I'm not so sure why an officer in the performance of official duties would just say, oh, you're a medical person? Let me just come on in here and help me secure the scene. So I'm not sure that I really, buy that. But on the opposite side of that, yeah, there's a lot that Chauvin could have done that would have been a little bit more sympathetic, empathetic to Floyd's situation. The judge says failure to render aid became particularly abusive after Floyd had passed out and while still being restrained in the prone position. One knee, 2.5 minutes, was unable to detect the pulse. So we know all of that. The use of the knee on the back while restraining a suspect was not part of any training by the Minneapolis Police Department. The placement of the knee on the back was an egregious abuse of authority to subdue and restrain Floyd, because he'd already been handcuffed for more than 4.5 minutes. So we've got that. So that was all part of subsection 1, that he abused a position of trust and authority. Then we move into the second prong. We've got also treated Floyd with particular cruelty. So same stuff in paragraph 1. We also know that they're saying that it was particularly cruel to kill Floyd slowly by preventing his ability to breathe, when Mr. Floyd already made clear he was having trouble breathing. Yeah, I know. That one, I know. The slow death of George Floyd occurring over 6 minutes because of his positional asphyxia was particularly cruel because Floyd was begging for his life and obviously was terrified by the knowledge that he was likely to die, but during which the defendant objectively remained indifferent to Mr. Floyd's pleas. Yeah, but he was complaining about not being able to breathe before he was even on the ground. He was complaining in the back of the squad car. So was he having trouble breathing then? And if so, what was causing that? Because nobody was on his neck or his back at that moment in time. Subsection D, restraining an individual in the prone position against a hard street, all while holding handcuffs arms for more than 9 minutes, is a particularly cruel act. Prolonged nature of the asphyxiation was by itself particularly cruel. All right, next we have children were at the scene, and we know that because we saw some of that. We heard some of the testimony that came out. Actually, some of the very first people were underage, right? And they 14, 12 maybe, they brought him in, and their testimony was powerful. And we know that because the juror who was ultimately excused, who was the alternate, didn't make it into the deliberation room. She said so. We went through her notes. Remember that juror? And she said, gosh, 14-year-old girl was crying. I felt that. That's all you need. If a juror said, oh my God, this person is causing a 14-year-old to cry, it's powerful. You can bring in all the, nanograms per milliliter and all this stuff of fentanyl. Nobody cares because there's a 14-year-old girl crying right in front of you. Children were present, standing only a few feet from where the defendant and other officers were restraining George Floyd in the street. Observed Mr. Floyd being asphyxiated as he begged for his life. 3 were 17 and 1 was 9 years old. Although these 4 children did not observe all the events, they did observe a substantial portion of Chauvin's use of force. And then we also have, he committed the crime with active participation of at least 3 other persons. And so this type of stuff is supposed to be, to stop sort of the dog piles that happen. You got a group of guys who were all sort of, kicking the crap out of somebody. Well, they were, it was like a gang ordeal type of a situation. And so, yeah, you you were engaged in a situation that was a dog pile, and you need to be penalized more for that because that is obviously unfair. If it's you on a one-on-one situation, all right, that's okay. But if it's a 4-on-1, like in this case, you plus 3 other people, well, that's just totally unreasonable. And because you are so unreasonable, we're going to add aggravating factors. That's kind of the theory here. Well, in this case, yeah, there were 4 people. They were all cops. Officers Lane and Kung were actively involved in the restraint of George Floyd that ultimately resulted in his death. Officer Thao was also keeping bystanders away, and there were even other officers there. Remember, there was the other officer who was securing Floyd's vehicle. No finding is made as to whether the active participation of officers was accompanied by intent or knowledge to establish that they are offenders subject to criminal liability. While they're being charged, and you better believe the government's going to ask for aggravating factors when they come down. So, and this was another point in the trial. It's like if Derek Chauvin was acting so recklessly, if he was doing things that any officer would go, no, that's crazy. You can't do that. Well, why were there like 4 or 5 other officers there at the scene who didn't knock him off or say, hey, stop this? There was the other officer who said maybe we should roll him over, flip him over, but nothing worth justifying anything further on that. Just say, no, he's good right here. We're gonna keep him right here. All right, sounds good. So you've got 3 other officers who were specifically there, the other officer who went and covered Floyd's vehicle, and there were other officers shortly thereafter, and nobody saw a problem with it except now they all see a problem with it. So the court, acting as the trier of fact with regard to sentencing, also finds that the government has not proven beyond a reasonable doubt that the victim was particularly vulnerable. So what they're saying here is that Floyd was handcuffed, and because you were sort of injuring a handcuffed person, that makes them extra vulnerable. And you get additional penalties for that. If you are restraining somebody and then beating them, well, that is very cruel, right? It's very sort of inhumane to do that, and they will penalize you for that. So here they're saying, well, he was particularly vulnerable because he couldn't even defend himself, and you were basically killing him when his hands were behind his back in handcuffs. So they're saying, well, judge says, although he was handcuffs, he had still been able to resist the arrest and prevent 3 officers from seating him in a squad car before he was placed in the prone position. So that by itself did not create a particular vulnerability. In this case, the drug intoxication did not also render him particularly vulnerable compared to other victims of murder. So, of course, the judge is not taking any of the drugs into account here. Restraining Floyd in the prone position with the weight of 3 police officers on him for a prolonged period of time also did not create a vulnerability that was exploited to cause death. It was the actual mechanism causing death. Signed off on by Judge Peter Cahill. So that means, folks, that the sentencing that Chauvin's going to be facing is likely to be substantial. Okay, 4 out of 5 aggravating factors. It's a lot. That sentencing has been pushed back. As we know, this is a screenshot from the court docket to Friday, June 25th at 1:30 p.m. And if you look over at the documents over there, you'll see that it's going to be a frenzy. Okay, a lot of media requests. A lot of people are going to be very happy about this. Sentencing day, you're going to see people doing cartwheels in the streets. Yeah, racial justice finally in America. Right? We'll see. Well, let's take some questions over from watchingthewatchers.locals.com. We've got Trow Pat in the house. What's up, Trow Pat? Welcome to the community. Says, with all of the evidence and testimony from the first trial being available to literally everyone, how would an appeal second trial work? Is it possible? Yeah, it's absolutely possible. The same thing. It would be the same thing. Now, they could change it, right? Now, they could change their themes. They could change their strategies. They could adjust it, right? You sort of redisclose a bunch of stuff and make some maneuvers. But yeah, when the judge remands it for a new trial, it's a new trial. And so they have to go through jury selection again. Everything we went through, they got to do the whole thing again, if that does in fact happen. Now, this one was a little bit unique because you're right, we all heard everything. So the defense is going to know exactly what Dr. Tobin said. And they would have a second crack at hopefully being more prepared because he, in my opinion, obliterated their case. Was very much the reason why I think that Chauvin was convicted, because of that testimony. Well, now they know it. They know what his game plan is. They know what his PowerPoint slides look like. They know what his little graphics and images look like. So they can prepare a response to that. And the government can do the same thing. They can bring in another Tobin, right? And beef his stuff, add some more PowerPoint slides in there, see how it works. So it is not ideal, right? You want to get it right the first time. And that's why everybody was sort of scratching their heads about a lot of the decisions that were made by Cahill and the court to not do certain things like change venue or even continue the case back. Even just keep continuing it. Continue it for another 12 months, another 12 months, just like what's happening out of Parkland, right? That happened in 2018. That trial still hasn't happened. So there's no real necessity to hurry a trial through in a situation like this. Now, that's not necessarily good for the defendants either, because justice delayed is justice denied. They want a close, a reasonable outcome. And of course, Derek Chauvin doesn't want this hanging over his head for 3 or 4 years either. And he's got the right to a speedy trial. So we're balancing a lot of these different issues. But the last thing that anybody wants to do is to have this happen again, which is why people are not happy with Brandon Mitchell, juror number 52, who may have blown the whole thing. Jeremy Matrida in the House says, does this mean the judge denied the mistrial? So I'm not sure that I've seen a ruling on that one way or the other. The judge is probably going to deny the mistrial, and they're probably going to appeal it. And I'm not sure where we're at procedurally with the appeal, Jeremy, but I have not seen anything about that. I know that the defense submitted their notice of motions, and that's the last I saw. The last thing I saw on the docket was a lot of the media submissions until this recent order came down from Cahill. We have LT13 in the House. Does this give any insight into how the appeal will go? Will he punt? So I don't know that this does give any insight into that. I don't think that Judge Cahill is going to do anything to sort of undo anything that came out of the trial. I think he's going to just try to button this thing up and move past it, and he's going to let the Court of Appeals and then ultimately the Supreme Court deal with it. Now, I don't think, again, that this has anything to there's nothing to glean from this opinion, I think, on the next level, because what's happening here is Cahill is keeping this very closed, a very closed universe. He's not looking into Juror 52. He's not looking into Maxine Waters or the settlement agreement or the lack of not changing venue. He's not looking at any of that. He's just saying, okay, listen, here's what we got. We had a trial. We're going to close this universe, and we know that the jury came back, and this is what they said happened. There's enough evidence that we can convict him on all 3 counts. And that's it. The judge is basically stopping there. The inquiry is not going any further. So based on that information, juror number 52, Brandon Mitchell, any mistrial, appeals, post-conviction relief, any of that stuff, it's a whole separate issue. We're just talking about somebody, Derek Chauvin or any other defendant, was convicted on 3 counts. We know what the charges are. We know that there are these aggravating factors. That's all that the judge is answering here. And we're going to get more information about the other stuff later. I really don't think you should read anything into it in particular, because I just don't get that from Cahill. I don't think that he would be trying to slide in a hint there. I really think that he wants to be done with this and let the Court of Appeals deal with it. We have Sharon Quinney in the House, says, wait a minute here. I don't think Chauvin got a fair trial, so how does this work? When do they get to a new trial? Well, they got to appeal it, right? They've got to find a basis for the new trial. They have to, take it up, and the court would have to remand it for a new trial. They're not just going to give him a second shot at it. He's got a pretty big hurdle in convincing the courts that is necessary, because as far as Cahill, in my opinion, he's going to come back out and say, nope, it's all good. Everything went fine here. And if you got a problem with that, take it up to the next level. LT13 says, if I were a police officer, I wouldn't arrest anyone, chase anyone, or get involved in any medical emergency. One bad angle, viral video, and your life is over. Yeah, I know, man. I know. When we sort of talked to Officer Tatum about that here on YouTube, I think a week or 2 ago, and he's, officers are feeling depressed. Police went from being sort of this heroic profession where everything that a cop did was saving America to this. Now every single cop who even looks at you is a racist neo-Nazi or something. Neither one of those made sense to me. But I agree, right? If you're in a profession that nobody appreciates the work that you do, find a different profession. I know it's easier to say that than it is to really do that. But long term, I'm talking 20 years from now, 30 years from now, right? Why would little Johnny, who 20 years ago said, I want to be a police officer, Mommy, and I want to go serve and protect my community. Well, now little Johnny's growing up and he's looking around and nobody wants to be a police officer. They are sort of the worst, sort of public servant that exists right now. Everybody's angry at them. Not me, but a lot of other people are. And they're just sort of on the receiving end of a brunt of a lot of pent up anger in America. And I don't think fairly. quite frankly, I don't think that the police are responsible for every single racial infraction that's ever happened in this country, but there are certain contingents on the other side that want to make it about that. And they have said so, that they need to defund the entire police because it is part of systemic racism that is inherently intertwined with the founding of America. And I'm not making that up. That's on BLM's demands on their own website. So you can go take a look at that. We have Osak71 in the house. Says, Rob, big fan. I'm a big fan of you, Osak. So do you think that Chauvin mitigating will offset his aggravation in sentencing? Well, no, I don't, because the judge already just came out. So I think I was a little bit inartful on that. The judge has weighed everything and came out on and made a decision. So we now know that 4 out of the 5 aggravating factors are on the record. The judge found that those did exist. So the judge would have weighed everything and come back, and this is the ultimate conclusion. We have Ghost Gunner in the house. What's up, Ghost Gunner? Says, what are the chances this gets appealed based on all the things that could have been corrupted the jury, along with a clearly biased juror? So I think 100%, if I had to say. It is going to be appealed. There will be many, many appeals and probably several appeals, and post-conviction reliefs. I mean, the litigation component of this is not over by any stretch of the imagination. And I think for good reason, because there are a lot of issues that took place here. And we've talked about that a lot. We've had Viva and Barnes on and other people sort of beating the Chauvin issues to death, but there were a lot of them that I think justify further inquiry for sure. Next up, we got, additionally, do you think that Judge Cahill might be irritated with him being named in the appeal and taking it out on Chauvin by enforcing the aggravated factors? Ooh, that's a very interesting observation there. I'd like to think he's not. He seemed fair during the trial. Yeah, I think I agree with you. I've been in enough courtrooms that you can sort of tell certain judges, they get seasoned enough that they sort of, nothing really bothers them. And I got that sense from Cahill. You could just sort of see by the way that he carried himself that there was not much that was going to flap him. He was unflappable. There was one situation where he scolded the Genevieve Hansen, I think the firefighter, kind of scolded her, but it wasn't, he never lost his cool. It was like, all right, I'm a judge. I got to scold this witness because she's not behaving. Let me turn this on for a minute. Put the angry judge hat on. All right, put the angry judge hat on. Now I'm an angry judge. All right, and then take the hat off, go back, whatever, right? It doesn't even matter because you've been doing it for 45 years. It's like just, changing, refilling your cup of coffee. That's how routine it is for judges. And that's the same sort of observation that I got from Cahill. I did not think that he was somebody who took almost anything personally. He just kind of wanted to run an even-keeled courtroom. I think that Nelson could come out and say Cahill was the biggest, awful, biggest, piece of garbage judge he's ever seen. Cahill's going to go, well, it's fine. I've been called that for the last 30 years. So whatever. And I just don't think when you've been doing it for that long that it is as personal as it might look, right? And you're making a good point here, Ghost Gunner, that you could easily expect human beings to act like human beings, and that includes judges. And there are many instances when judges do that. When judges, I know judges here in Arizona, I go, oh gosh, we do not want to be in sentencing in front of this judge because this judge is just not friendly for you or your demographic or whatever. But I just didn't get that from Cahill, and I know that is kind of speculative and not really based in much other than my gut instinct, but that's all I got. We have No Doubt says, after watching the complete trial, the prosecution did not prove he was guilty of any of the murder charges beyond a reasonable doubt. However, I did find him guilty of cruel and unusual punishment, though he wasn't charged with that. We need a set of laws that deal with official oppression rather than just a broad category that police officers and other government officials are subject to. Yeah, so what you're kind of talking about there, No Doubt, are lesser included offenses, and the government didn't include anything less, right, strategically, because they wanted to make sure they got convictions on the murder charges. If they would have included some of those lesser offenses, the theory from a prosecution perspective is that you would be giving the jurors an option of picking something less. They don't want to give them that option. They want to convict on the most serious charges. What's up? Liberty or Death in the house says, hopefully the public doesn't see this for the other 3 officers. First, the DOJ broadcasts they have been indicted. Now they were part of a group that killed Floyd. Do you think the judge will grant a change of venue for the other 3? It's hard to say yes, right? What if they do? I don't think so. I think they have to say no, because if they do change venue, well, why didn't they do it for Chauvin then? Which was obviously the bigger case. So I think as a matter of consistency, they can't change venue now. They got it. Nope. It was fine to do it here in Minneapolis when we did it with Chauvin. It's going to be fine to do it with the other officers. Otherwise, if they say, oh my gosh, yeah, that was a disaster. Yeah, we held Chauvin's trial here. It was a friggin' nightmare. We had Maxine Waters coming in here, lighting buildings on fire. Not that she did that. And then we're going to change it? All you do is that at that point is then open the door for Eric Nelson to come in and say, see, we told you so, jerks. We told you we needed to move this thing. You didn't do it. Now you're doing it. You should have done it for Chauvin. Now I'm asking you to do it so that we can have a new trial that is in fact fair and impartial. Just that would be my instinct on it. Jeremy Matrita says, nothing about this trial was based in fact. I have no faith in our current justice system. Ugh. I know. To what end does this meet by crucifying 4 police officers? To what end does this meet by crucifying 4 police officers for doing their job? Well, Jeremy, it makes a certain segment of this country feel good. I think that's all it does. I mean, I don't know what else it does because it's not going to change anything in the justice system. What's Minneapolis going to do? They're going to defund the police by $8 million. Then they bring it back, I think, another $6 million. We just talked to Ricada Law here on Monday, right, and he's saying that some of the external police departments are just not going to go in and support some of the inner city police departments, and that there's this sort of division that's going on. So is justice improving? We're talking about defunding the police now. Is the George Floyd bill going to pass? It doesn't do anything for anything. We've gone through that bill. So what's going to happen here? We're going to have 4 officers who just go to prison, go to custody, and we're going to have a family that gets $27 million. You're going to have a lot of people that make a lot of money and make names for themselves by starting podcasts and writing books and fighting for some sort of cause that doesn't really do much of anything. We went through the demands that BLM has. What are they? They want Donald Trump off the internet and they want to defund the police. So, okay. So they've got a lot of momentum here as a result of this Chauvin verdict. What are they going to put it to? What is going to go to good use for anything? I read through the 7 demands on the show. I can't see anything that's going to be useful for real justice reform in this country other than defunding the police. So they want no police. That's a good starting point. So what's going to happen? Nothing. But a lot of people in the media are happy about this. And a lot of people just kind of got that, it's kind of like the Colosseum. I mean, really, when you think about it, back in the Roman days, we used to have over there in Rome, they used to have these battles where gladiators would go in, lions, tigers, bears, oh my, and they would kill each other. It would be a public sport because people wanted blood. They didn't like their lives. They didn't like what they've been being told. They don't like this idea that America is a certain way, and so they want blood now. And how are they going to get it? Well, it's going to come out of the court of law. It's going to come out of Derek Chauvin and these 4 officers, because where else can it come from? It's not going to come from our politicians. We've had the same stinking politicians my entire time practicing law promising us all these changes. Oh, we're going to improve this, and we need a committee, and we need a research team over here, and we're going to go talk and do some community policing and go interface with the little people down there that we're patrolling. All right. Anything changed? No. Any real meaningful reforms across any part of the country? Not that I have seen, truly. I mean, it's more of the same crap. Every time the police kill some black kid, it's the same garbage. The mayors stand up, the governors stand up, all the senators stand up. They go, up. This is just awful. We're better than this. We can do more in America to stop this from happening. And then what happens? Nothing happens. Nothing. We have a trial. Cops go to jail, and it's just status quo moving forward. Joe Biden comes out, addresses the country, talks about it for like 15 seconds, and then mentions pass the George Floyd bill. That's it, right? Are we expecting anything from him? No. He's got 30 years of criminal justice ear reform, of slamming people behind bars and throwing them in custody for 30 years. And his VP is Kamala Harris. So somehow, some segment of this country thought that these 2 knuckleheads were going to be the saviors of our justice system. Give me a break. It could not be possibly worse. But still, they are getting a lot of the benefits because they have everybody in their pocket. They've got all the media, all of the politicians. Nobody wants to stand up for any of this stuff. And what happens? The people suffer. Government does fine. Everybody else who's on the receiving end of, bad policing and now rioting, we're all suffering the consequences because the police aren't going to want to go in and clean up the streets. And we kind of need them to do that now, because if they're not doing it, who's going to handle it? BLM? Thank you for that, Jeremy. Joe Snow is next. We've got, listen, I don't know where I am or what position I'm being detained in. If I'm in handcuffs and I tell the police I can't breathe, I need medical. Yeah. So did George Floyd, evidently. We have Sharon Quidney says, how can a law enforcement officer be held responsible for the presence of children? Should they change their tactics just because kids can see what's going on? And where were the parents? Doesn't make any sense to me at all. Yeah, so that is interesting, right? Because these are aggravating factors that are usually for defendants, right? This is usually for, the guy who's beating his wife in front of his kids in their, apartment building. That's what this is for. It's not for an officer arresting somebody and 3 other cops were there. It doesn't, they're sort of not written for that. All right. We have next up, we've got Liberty or Death says, pretend this happened in AZ and you were counselor. What is the procedure that you would follow and your next steps? Well, sentencing is what we would be doing. So in Arizona, the way that this would work is we have sentencing. So Chauvin would be going over and he would be going and having what's called a pre-sentencing report that would be done here by the Maricopa County Probation Department, essentially. And they would be sitting down with him and they would be doing an interview with him. At this point in time, we'd also be working with a mitigation specialist, somebody that is only focused on mitigation. That probably would have started a long time ago, but they would also be working on the case. We would be preparing to go down and be there, a part of the pre-sentence interview. We'd probably have a sentencing court date that would be scheduled, and very, very unlikely that there would be sentencing that would take place at that time. What we would probably want to do is go there and then have probably a meeting in chambers with the court. Probably what they're going to do here in this case, talk to the judge, talk to the prosecution, talk to the probation department, figure out kind of what everybody's asking for. When it comes to sentencing, so here's the way that it works. You'll have the defense is going to come out and make their offer. The prosecution is going to make their offer. And then you're going to have sort of what's supposed to be an impartial, unbiased analysis that is typically done by a third party. In this case, it's the court or it's the probation department or an extension of the court that is more under their arm, not the prosecution's arm. So you're going to have 3 different reports kind of coming in there, skidding in there, sentencing recommendations and so on. All of those come skidding in. Once they're all prepared at the sentencing court date, you're probably not going to sentence on that date because you're just going to be getting a lot of this information. So you're going to ask for a continuance or an extension, or what we call them our mitigation hearings, further down the road. Then you can sort of reconvene, come back, and have a powerful sentencing. Bring in everybody, right? And if you're Derek Chauvin, at this case, you're bringing in everybody, wife, kids, family, every single human being to come in and talk about, what a great person he is, other fellow officers, and you try to cram in as much as you humanly can for the courts. So that's what we would be preparing for. Also, I don't do appeals truly, so we would be working with an appeals attorney and a post-conviction relief attorney. I mean, I don't do the appeals. We do that here at the firm, but I don't personally do them or have much experience with them. That's for the people who love to write and read and research and just read and read and read and write and write and write and write. And I don't have. I'm well capable of doing that. I just prefer to come rant here on YouTube. So it's a good question, Liberty. There's a lot going on there. We have next up, last one on this segment, comes from Software Nugget. Says Chauvin is definitely innocent. The prosecution didn't make their case, but a lot of people think that you're a horrible person for thinking that. But Chauvin was simply doing his job. Yeah, and Software Nugget, my perspective on this has always been that the beyond a reasonable doubt standard just wasn't met. I think that there was plenty of reasonable doubt in this case. I am not endorsing anything that Chauvin did, right? I've said for a long time, I agree with the witness who called him a punk. I think he is a punk. I've seen many officers like this who just think that they have unlimited power and that they can go do whatever they want. I'm not excusing anything that Chauvin did. But the government still has to meet their burden, and they got to prove him guilty beyond a reasonable doubt. And when I looked at the case, fentanyl, methamphetamines, last-minute drug ingestion at the scene, hypothetically. We've also got the 2019 case where his blood pressure was like 216 over 160, something insane. And the list goes on and on. Plenty of reasonable doubt. The government's own witnesses said that if they would have walked into his apartment and found him dead, they could have attributed it to a number of different causes. Either the fentanyl independently by itself could have done it, or his heart condition could have done it. 90% clogged arteries out of his arterial sclerosis and hypertension. So plenty of reasonable doubt there. All right. Great questions. Thank you so much for those. Those all came over from watchingthewatchers.locals.com, and we really appreciate your support. We've got a lot of good events coming up over there, and I'm excited about that platform and where it's going. So thanks for supporting us over there.